The problem is you've got people, there are a group of people for whom that does not work. They value assets as, they worship their assets. They are very greedy people. They're not honest, and they don't think that they have to comply. So therefore, what you need to do is skip past them and go after the asset. Follow the assets and follow and hit the recipient of the asset. UFTA creditor remedies. The UFTA is a very powerful statute when used correctly. The first remedy that I wanted to talk about, and I did a little bit before, is the remedy of avoidance. You can set aside a fraudulent transfer under certain circumstances. Make the asset come back. In essence, you are going to be turning around and suing the recipient of the transferred property. Go after them. If it's a new girlfriend, a new spouse, trust me, that is not going to make your opponent particularly happy. If you represent a wife and the husband has fraudulently transferred an asset to his new trophy wife, and now she's facing a lawsuit where she could be hit for a couple $1 million, he may be sleeping on the couch. That will get you results. You can get an attachment or a provisional remedy. Attachments are something that's typically associated with collections. Under the Fraudulent Transfer Act, you can obtain any relief that you could obtain under the Attachment Act, which is part of the Code of Civil Procedure. You can get an injunction. Injunctions can be powerful weapons. They can be more powerful, as I kind of alluded to during some questions with respect to Lane's discussion. The Fraudulent Transfer Act is one of the few places where you can actually get something in the nature of an equitable attachment under the right circumstances. Be careful here, though. You will need very compelling proof, or the judges will very likely say, gee, we don't feel comfortable doing that. In an extreme case, you can get a receiver appointed to take control over property if you think if it's going to leave, or if it's being otherwise dissipated. You can try and levy on the transferred asset or its proceeds if you have a judgment. Now let's talk about something that's, there's a question?
Instead of filing a lawsuit against the girlfriend who has the stock transferred to her, why wouldn't you just join her as a necessary party to the divorce proceeding and then give the judge the jurisdiction over that person? Wouldn't it be cheaper and faster?
You could do that. That has some significant advantages, and one of the advantages is that may provide you a better entitlement to fees. But when you do that, whether you sue the third-party transferee within the case or whether you do it in a separate case, you're still suing the third-party transferee. I mean, what you're talking about is essentially amending the complaint and adding a new defendant.